5 seconds to go. Start. Therefore, even assuming that the defendant had committed breach, if the plaintiff fails to ever in the plaint or prove that he was always ready and willing to perform the essential terms of contract which are required to be performed by him other than the terms the performance of which has been prevented or waived by the plaintiff, there is a bar to specific performance in his favor. Therefore, the assumption of the respondent that readiness and willingness on the part of the plaintiff is something which need not be proved if the plaintiff is able to establish that the defendant refused to execute the sale deed and thereby committed breach is not correct. Let us give an example. Take a case where there is a contract for sale for a consideration of rupees 10 lakhs and earnest money of rupees 1 lakh was paid and the vendor wrongly refuses to execute the sale deed unless the purchaser is ready to pay rupees 15 lakhs. In such case, there is a clear breach by the defendant. But in that case, if the plaintiff did not have the balance rupees 9 lakhs and the money required for stamp duty and registration or the capacity to arrange and pay such money when the contract had to be performed, the plaintiff will not be entitled to specific performance even if he proves breach by the defendant as he was not ready and willing to perform his obligations. In Pandit Prem Raj versus DLF Housing and Construction Private Limited and another cited by Mr. Venu Gopal, this court held that it is well settled that in a suit for specific performance, the plaintiff should allege that he is ready and willing to perform his part of the contract, and if the fact is traversed, he is required to prove a continuous readiness and willingness from the date of the contract to the time of the hearing to perform the contract on his part. In DLF Housing and Construction Private Limited Supra, in the absence of an averment on the part of the plaintiff in the plaint that he was ready and willing to perform his part of the contract, it was held that the plaintiff had no cause of action so far as the relief for specific performance was concerned. In this case, of course, there is an averment in the plaint that the respondent plaintiff was all along ready and willing to perform his obligations under the contract. The question is whether the respondent plaintiff had proved his readiness and willingness to perform his obligations under the contract. This court reiterated that section 16C of the Specific Relief Act 1963 envisages that the plaintiff must plead and prove that he had performed or has always been ready and willing to perform the essential terms of the contract which were to be performed by him other than those terms the performance of which has been prevented or waived by the defendant. This court said that the continuous readiness and willingness on the part of the plaintiff was a condition precedent for grant of the relief of specific performance. Stop.